That's the problem of people from the outside analysing the case law with their spectacles. And I can see that it may well be people who only ever lived in a continental legal system, or people who've only ever lived in a common law system, may have problems in understanding this or that judgment or the case law. But I would simply say from the inside, there has never been any clash of, I'm not revealing any secrets of deliberations, but there has never been, and I was there from 74 to 2005, I never saw any clash of legal culture as being responsible for a sort of problematic drafting in judgments. There were problems, there were quite often fights between, but it's really philosophical fights over whether the Strasbourg court should be wagging its finger at national jurisdictions, in other words, deciding everything, or whether it should be recognizing a margin of appreciation, this idea of subsidiarity. Whether you say there's an obligation of result, but we let each culture, each democratic society, as far as possible, decide for its own people. And we only intervene if they've gone outside what is acceptable within a democratic society. But otherwise, we let them get on with it. Each country, they elect their parliaments, they elect their town councils. We should only intervene. That's one school of thought. There's another school of thought that says, no, we should be giving them lessons whenever we disagree with what they've done. The disagreements that produce, judgments are produced by committees, not by a single judge, and all committee documents are always compromises. So there are judgments that are badly drafted, clear, but it's mainly because of philosophical differences between the judges, not because of national differences.
If I may follow up just on this last point briefly, I'm wondering about the legitimacy of the court. Especially, well, the court in terms of input legitimacy is apparently legitimate. People address their applications to it. But what I'm having in mind is something else. It is this kind of sensitive cases in which the court's decision interferes into the so-called national constitutional identities. Such as, for example, Lautsi case, whereby the court is faced with the question whether the Italian authorities are allowed, are permitted to hang their crosses in the public schools or not. And this is something which is an issue which is very difficult to be decided by the National Constitutional Court, which has its own constituency. Whereby when you have the European Court of Human Rights, which is detached and operates with a margin of appreciation, all this, I'm wondering, what would you say in this kind of hard cases? Should the court go into the direction of a wide margin of appreciation, or should interfere more as the first chamber did in this particular case? I'm asking because we discussed this case with students, and it was quite controversial.
Well, I remember when that judgment came out, I was in London at a lecture in Lincoln's Inn, and I was sitting next to the then president of the UN International Court of Justice in The Hague, British woman, and she said to me, your court has just delivered this absolutely extraordinary judgment. She said, I always thought that the relationship between the state and the church was for each country to decide. And I said, well, one, it's not my court anymore, because I am now on the Court of Justice in Luxembourg. But I said, I tend to agree with you. The margin of appreciation, whether it's a wide one or a narrow one, depends on the context. And when you're talking about the right to liberty, when you can send people to prison. The narrow, it's very narrow. Or free speech, when it's a question of expressing political opinions, it's very narrow. But on other areas, it should be wide, where the opinions can vary legitimately from one country to another, or even from one epoch to another. I really think that it's not the role of the Strasbourg judges, just because they happen to have strong views on this particular issue, as you may have strong views on whether there should be crucifixes hanging up in schools. But personally, as a European citizen, I would prefer that this kind of controversial issue be decided by civil society. In other words, after debate on the television by journalists, and then in Parliament the different political parties commented on, and then you adopt it. I wouldn't want this being decided by someone in Strasbourg just because they happen to have a strong view on it one way. I wouldn't want you deciding on it just because you happen to have a strong view on it. I would prefer that these kind of controversial social issues be decided by civil society according to normal democratic processes. And what you can do in Strasbourg is make sure that the normal democratic process has been followed. That there has been a proper open debate in Parliament, for example. But there are some countries which are laïque in French. France, Belgium. It's written in their constitution that schools must be lay and you can't have religious signs in the school. Fine, those countries can put it in their constitution, and the Constitutional Court can then stop schools or universities putting up crucifixes. But in other countries, no. The Constitution doesn't say that. In some countries, there is a link between a given religion and the state. And in those countries, they are just as democratic. To my mind, the European Convention on Human Rights, when it guarantees this educational freedom, it does not impose on the whole of Europe the French and Belgian view, which is a lay state. No, that's what they have chosen. But the European Convention on Human Rights doesn't impose that on the whole of Europe. All that the Convention does is to say that people must be able to practice their religion freely. They should be able to found churches, not as in Greece, where only the Greek Orthodox Church could own property, and where they systematically stopped Jehovah's Witnesses and other Christian churches from operating. No, you can't let states use the law or administrative practices to stop people practicing their religion. You shouldn't have propaganda in schools for one particular religion. You should allow people to opt out. But that doesn't mean that you can't have a crucifix on the wall. I don't see how that represents an interference with religious freedom. I was a Roman Catholic. I went to Protestant schools until I was 14, and I didn't have to go to the religious ceremony they had every morning. And it was wonderful. It meant I had 40 minutes in which I could do my homework, whereas all these other idiots were having to sing hymns and the rest of it. And I never in any way felt they allowed me to practice my religion. And in Lincoln's Inn, after this lecture, there was a dinner, and everyone who was present at the lecture was invited to stay for the dinner by Lincoln's Inn. Before the dinner, there was a grace said in Latin, and there were people standing around the table wearing turbans. There were Jews, there were Muslims, there were Roman, but this was the tradition. Lincoln's Inn has always had its dinners preceded by a grace in Latin. But none of the people there felt offended. They just took this as being part of the tradition. It may well be that with time this will change, but I don't think you can say that constitutes a violation of human rights. I think this was, the chamber went too far. they felt strongly they wanted a lay state, but then if you want a lay state, get your politicians and your parliament to agree to it, but don't impose it on everyone else. This is, to my mind, there are areas where you have to allow societies to evolve at their own speed. So the main judgment in Laozi, the Grand Chamber judgment, is not that well drafted, I don't think. It's a bit weak, the drafting and the reasoning, but the result is the right one, I think.
Okay.
That's my personal view. I mean,
Sure.
you may well have different views. Yeah?
Sure. You should have been here when we had the discussion of this particular case. It was very, very...
Yes, well, this is an area where people do have strong views. But as I said, the fact that you have strong views doesn't mean... I think this is when there are conflicting strong views in a society, this is an indication where there is no set answer that can be imposed from Strasbourg. This is an indication that this is where the local society should decide, but making sure there's no bad faith and the democratic process is being followed.
Okay, we're slowly running out of time. I saw one last hand raised, so it's your turn for the last question.
Well, thank you, Mr. Margoni. Thank you for an interesting presentation. I would also like to thank Professor Jambrick.
Will you shout, please, for me?
I'll try to.
Yeah.
I'm not a lawyer by profession, so I'm going to have some really short and simple questions and maybe a comment. The first one would be, we also discussed in the past lessons the case called Lukenda, which was interesting for Slovenia because I think that the judgment was that there's a systematic failure in our judicial system because the cases are not being brought in the reasonable amount of time. On the basis of what you discussed, what we heard today, is also then the court, your previous court, has also a systematic failure. If the guy who applies for he expects in a reasonable time is not provided by one. That would be my first one. The second one would be regarding, you also mentioned in one of your proposals that you would decrease the number of judges in Strasbourg. So that means that not every member country would have a judge. Would that decrease the buy-in from the member countries? Because we had a similar thing. There was a proposal with the European Commission that the number of the commissioners would go down because of the rationalization, the financial aspects. And the countries opposed that because the member countries would not buy in. They wouldn't have a member on the team. So what would be your take on that? Also a comment. You also mentioned Moldova and the 14th Russian Soviet army, led by, I think, the famous General Alexander Lebedov. I think that the role of I don't know the case in front of the court, but I think that the role of the 14th army under General Lebedov was to protect the ethnic Slavic population in Transnistria, not in Moldova. But that was just a comment. And I'm going to stop here. Thank you.
Thank you very much for these interesting comments and hard questions for which you have reasonably really little amount of time.
Okay. Well, length of proceedings is a systemic problem in many countries. And this led the court to interpret the provision of the convention which says that states must provide an effective domestic remedy for alleged violations of the convention. The Polish case called Kudla. And the court then said, states must make available at national level an effective remedy for complaining about length of proceedings. Yeah? And many countries didn't. And the prime example of that was Italy. When the single court was set up, we discovered that the Commission had a room in which there were stacked up something like 40,000 applications against Italy concerning unreasonable length of civil proceedings. And those applications didn't appear in the statistics anywhere because they hadn't been registered. The Commission didn't have enough staff to register them, so they simply didn't appear in the computer system at all. And the Italian Court of Cour des Comptes had said that as far as Italy was concerned, it was cheaper to keep paying the damages awarded in Strasbourg rather than reforming its justice system. It would cost too much to reform the justice system. It was cheaper simply to continue paying the damages in Strasbourg. And it was to stop that kind of situation that this Kudla judgment was delivered. The Italians did adopt an internal law offering a remedy. And so all those 40,000 cases were registered and then sent back to Italy. They were told, you now have a remedy, exercise it. Of course, they started to come back on the basis that this remedy was taking too long. So that's another. So generally speaking, if there is a systemic problem of length of proceedings in Slovenia, you should first of all check whether there isn't available at national level a remedy for dealing with that. And if there isn't, then attack Slovenia under Article 13. I mean, I don't know the details of that case. Argue that not only have the proceedings lasted too long, but you didn't even give me a remedy for being able to challenge this at home. And with luck, that will then tip back all these cases into the Slovenian national system. This has worked for some countries. In Spain, there are hardly any cases now concerning unreasonable length of legal proceedings. Although there were initially, they introduced a remedy and it works well in Spain. So there the remedy has worked. On the second one, the question of courts, what I said was that each state should have a judge on the lower court. Yes, at the upper court, not necessarily so. The Inter-American Court of Human Rights in Costa Rica doesn't have one judge for every state. There is a rotation. The ICJ, the UN, doesn't have one judge for every state. The International Criminal Court doesn't have. There are many, many international courts where you have a multitude of contracting states where they don't have all the time one judge for every state. Also, the argument that it's undemocratic not to give each country its own judge is also, I think, a little dodgy in terms of logic. There are 150 million people in Russia. Each Russian citizen, one judge, 150 million. There are 14,000 citizens in Andorra. They have one judge. Andorra isn't even the size of a suburb of Moscow. Why shouldn't all the suburbs of Moscow have one judge? Why? And it's undemocratic, I think, to allow Andorra one judge, the same status, means Andorran citizens have a far higher participation in this system than Russians. That's undemocratic. So this argument that democracy demands every state has a judge, no, I don't think so. If you have a case against Andorra, you could have an Andorran judge, a system of, as they have in the ICJ. So what I propose is that you would have one judge for every state at the lower level for the filtering, but the court dealing with the main cases should be plugged into the national systems more. In other words, like the old court, judges who don't live all their 9 years in Strasbourg, but they live in their country. They're in permanent contact with the vital forces, in inverted commas, of their own country, and they just come for meetings. You have, I think, a more reliable reflector of human rights feelings in the countries in that way, personally. That was I think in terms of the reliability of judgments, the old court was much, much better. Back to quality, right? I think the reliability of what is acceptable or not in democratic society was greater in the old court because the judges were still in day-to-day contact with their own national society. And then on the last one, oh well, yes, it's true, Transnistria was made part of Moldova after the Second World War by Stalin. He chopped off large parts of Moldova